Good afternoon. My name's Rob Morris. I'm with the Trust and Estates Department at Stark and Stark. Thank you for joining us today for our seminar, Estate Planning for Singles and Couples with No Children. Before we actually get into the seminar, just a little bit about our firm. Stark and Stark is a full-service law firm. Obviously, we practice in a variety of areas, everything from estate planning to family law to business and transactional, and of course, many people know us for personal injury. So if you have any questions over and above what we're going to cover today regarding estate planning, please feel free to reach out to either me or any member of our firm, and we'd be happy to either answer your question or get you to somebody within the firm that can. So again, we're here today for estate planning and uh, for singles and couples with no children. Here's an outline of what we're going to talk about. We're going to talk about estate planning related taxes. Okay, unfortunately, in this particular area, because of the way the tax structure is in both New Jersey and Pennsylvania, these taxes are very important for singles and couples with no children. We're going to talk about a few different estate planning issues and options that are somewhat unique to this particular group of clients. And of course, if I don't cover your particular issues, please feel free to reach out to me. I'll give you my phone number at the end. You're welcome to reach out to me via phone or email, and I'd be happy to discuss whatever is unique to your estate. So before talking about the issues that are unique to singles, we need to kind of frame the issue, right? So a good way of framing the issue is understanding what's involved in basic estate planning documents. So to me, and of course, everybody's got a different opinion, but to me, the fundamental estate planning documents are a healthcare power of attorney, a power of attorney, and a will. If you don't have those three documents, you're leaving yourself open to some fairly serious issues that we're going to talk about in a few minutes. Of course, I put revocable trust up on the slide. That's not for everybody, but they are an important tool, particularly in this particular area. And I'll show you why towards the end of the seminar. So let's dig right into these documents. The first one we're going to talk about is a healthcare power of attorney. And by the way, if you don't do anything after today's seminar, that's fine. That's your prerogative. I will, however, say that you absolutely need, regardless of your age, a healthcare power of attorney and a power of attorney. These two documents are very, very important, and here's why. All right, so the healthcare power of attorney allows you to appoint a person who's deemed to be an agent of yours to make medical decisions for you. So why are you doing this, right? If you're ever incapacitated, the doctors are not going to be able to get an informed decision from you. And if they need to have decisions made, right? Should I have this procedure or not? Can I consent to the following types of treatment? You're incapacitated, you're not making that decision. So automatically now there's a problem, and it's pretty significant, right? They're coming to you because you need this medical treatment. And if you're not able to authorize it, then who's going to do it, right? Sometimes they'll let people squeak by if a spouse approves it, but really to just eliminate the issue altogether, it's highly recommended that everybody have a healthcare power of attorney. Now, every healthcare power of attorney needs to have a primary agent, right? And that's going to be the individual that you appoint to make these decisions for you. For couples that are married, that's typically the spouse. Not always, right? Sometimes when they're older in life, the spouse has their issues too. So maybe we'll go to another family member. But 9 times out of 10, for married couples, it's the spouse. So right off the bat, you singles out there, obviously you don't have a spouse that's going to be available. So the important thing is who's going to serve as your primary agent if you're a single person, all right? So for singles, what do we typically see? Often it's another family member, sometimes a brother or sister, sometimes a parent. You have to be careful about pointing your parents because, perhaps you're young now, but if you need this document 10, 20 years from now, your parents may be much older or not available. So you have to keep that in mind if you're appointing somebody who's older than you as your primary or contingent agent. So for both singles and couples that don't have any children, another issue is who's the alternate agent, right? So you do these documents to think, all right, I've got a primary agent, I'm done, I don't need to do anything else. Well, guess what? The primary agent may have problems of their own they're not infallible either. So you really need to be thinking about who is going to be your alternate agent. And sometimes these can be very difficult decisions for people to make, right? Because, all right, well, I've got a primary agent. That's going to be a brother or sister. They're not available. Okay, well, who's next, right? And that sometimes can be a difficult issue for couples with no children and for spouses. So important issue for you to consider. The next document we're going to talk about is a power of attorney. So when I talk about a power of attorney, what I deem them to be is for financial and legal decisions. So what you're doing here is you're appointing an agent again. So instead of making medical decisions, this agent is going to make financial and legal decisions for you. So it's the same basic issue, right? You're incapacitated. Your bills are piling up. You may own a house. Who's paying the property taxes? Who's paying the utilities? If you're incapacitated, it's not you. So who's this person going to be? And that's why this document's really, really important. All right. So this is going to be an individual that's going to manage your day-to-day affairs. And for those people that have a lot of assets, this agent's also going to be managing your assets. You know, sometimes clients are incapacitated for a while. And the primary agent's going to be managing your investments over a long period of time. All right. So it's a very, very important agent role to fill. All right. If you're a married couple, again, 9 times out of 10, the primary agent's going to be the spouse. So for married couples, the issue is often if my spouse is unavailable, who's next, right? Figuring, a related issue on this, that we're possibly not going to need this power of attorney until late in life. And if I'm late in life, who's still going to be available, right? Talked about this issue a minute ago. It's not going to be your parents. It's probably not somebody who's older than you are. They're going to have issues of your own. So you're going to have to pick an alternate agent that's younger than you. All right. And that can be a difficult decision to make. Singles, again, same issues. Who's going to be your primary agent? And if your primary agent's unavailable, who's going to be your contingent agent? All right. And the scope of authority for this power of attorney is different than the healthcare power of attorney. The scope of authority here is for financial and legal decisions. And sometimes people just want to slap somebody down, right? Oh, I got an agent. I don't think about it. I'm just going to stick in this family member and that's fine. Well, you have to really keep in mind that this person's going to be making financial and legal decisions for you. And bottom line is not everybody's good at making financial and legal decisions. In fact, some people are actually really quite poor at making financial decisions. And I'm not talking about, ripping you off or doing something that's untoward. What I'm talking about is they see a financial decision and they panic, right? And then everything grinds to a halt, no decisions made, and the problem persists. So bottom line is it's very important to pick an agent who's capable of making financial and legal decisions for your financial power of attorney. All right. So the alternatives, and this is why at the beginning I said these 2 documents are really important. Again, just for frame of reference, the documents we're talking about are a healthcare power of attorney and a power of attorney for finances. So the reasons why they're important over and above what we just discussed is if you don't have them and you're incapacitated, well, guess what? Every state's got a plan for you. In New Jersey, we refer to it as a guardianship. In some other states, it's referred to as a conservatorship. And what's happening here is you're having to petition the court to appoint a guardian for you. All right. And that guardian's going to step in and make these financial and legal decisions for you. I put up on the slide a couple of issues that go along with guardianships. Number one is they're very expensive. The person who's applying for guardianship has to hire an attorney. You, as the incapacitated person, will get a separate attorney. So you're probably looking at another $2,500 there just for the court-appointed attorney. In some extreme situations, there would be a guardian ad litem. So that'll be 3 attorneys working on the guardianship. You can figure it out. That's a lot of attorney time just to appoint a guardian. The related issue is that guardianships can be time-consuming. Right? This is a court action. You're asking the court to basically strip away the rights of the incapacitated person and give them the guardian to make all these decisions for the incapacitated person. Well, the court's just not going to do that, right? They're not going to be, oh, that's fine, right? Here you go, right? These processes take a long time. typically at least 6 weeks, depending on the court schedule. They may take longer. Meanwhile, again, these decisions are all racking up and nothing's occurring. So the bottom line is that guardianship can be very expensive, both in terms of legal fees and time consuming in terms of getting it implemented. All right. So let's put aside those two documents, the power of attorney and the power of attorney in healthcare. And then let's talk about your will. So also very important to me, and hopefully to you as well, is that you have a will in place. All right. So the first issue for singles and couples with no children are who the beneficiary is going to be, right? For couples who are married but don't have kids, the primary beneficiary is usually not an issue. That's going to be the spouse, and they're going to receive oftentimes 100% of the assets, but that may depend on what you want to do. The issue for both singles and for married couples with no children is who's next, right? Who is going to receive my assets if a spouse is unavailable? And for singles, who's going to receive my assets from the get-go? If you're a single person and you have a child, okay, well, maybe that issue is not as acute, but we're going to talk about a couple issues regarding minor children. All right, so if you're single and you have a minor children that's under the age of 18, just listen up. We're going to talk about some very important issues that are going to affect you. For singles that don't have kids, the beneficiaries can oftentimes be an issue, right? Again, you may revert back to your closest family members, sometimes often a brother or sister, sometimes the parents. You have to be careful about naming your parents as a beneficiary, particularly as the parents get older. And if they need nursing home treatment and they're headed for a nursing home, and you leave your money to that parent, they wind up in a home, well, guess what? The money may go to the nursing home and not really necessarily benefit your older family members. Okay, so very important there. If some family members aren't close, sometimes we'll have clients that'll leave money to friends, all right, and that's fine. And sometimes we'll have clients that'll decide, hey, I just want to leave some of my money to charity or all of it, depending on what their circumstances are. Obviously, it's important to know what charities you want to leave your money to when you're starting this process. All right. Another issue is the executor and trustee. All right. So who are these people going to be? All right. So let's talk about what their roles are, and then we can discuss about maybe some options to fill these positions. So every will should, if it doesn't, it's a mistake, but every will should appoint an executor. So what's the role of the executor? The executor is a fiduciary, and their main role is to settle the debts, taxes, and expenses of the decedent. So they're settling their estate, they're winding up their affairs, they're receiving and collecting assets. That's the role of the executor. Once those functions are accomplished, then the executor makes distributions from the estate to the beneficiary in accordance with the will. So the executor is a very important position to fill. All right. Same issues affect the executor that affect the power of attorney that we talked about. All right. Number one, who is this person going to be? And number two, am I picking somebody who's qualified to fill the position? Again, I can't stress enough. Many people just pick a relative just because they feel like they have to. Right. Well, don't feel that way. If the relative's not capable of making decisions, particularly financial decisions, probably not a good choice as executor. All right. And you may be better off trying to find a friend that'll fill the role or somebody else that you feel is capable of filling the executor role. All right. Again, it's very important. I've seen estates sit for years and years and years because the executor just can't make decisions. All right. So again, a very important role to fill. All right. The second role I have up here on the slide is a trustee. All right, so trustees, sometimes done for tax reasons, but today we're just kind of talking about basic issues. So let's talk about some basic issues where you might see a trustee. All right, one major basic issue is if some of your beneficiaries are minors, right? So if your beneficiaries are under the age of 18, my opinion, right, you really need to have a trust for these minor beneficiaries, all right? Here's why. If you just leave assets outright to a beneficiary, they may go in one of two places. Right? They may either go to the surrogates commingled fund, or you may force the parent of the minor to go out and get bonded for them, and now you're just throwing money out the window. So to avoid this issue, you need to have a trust under your will or set up a separate revocable trust to provide for these minor beneficiaries. All right. The trustee, what's their role? So the trustee is going to receive the assets from the executor of the estate or by beneficiary designation. And the trustee has two main roles, right? They're going to manage the trust, which means they're going to handle all the investments and make investment decisions for the beneficiaries. You know, how's the money invested? Is it in stocks and bonds? Or are we going to be conservative and we're just going to put it into money markets, right? That's really up to the trustee and the purposes of the trust. So that's one major role. How's the trust invested? The second major role is how does the trust make distributions? All right, so there may be terms for making distributions to the beneficiaries. These all should be spelled out in the document. You know, sometimes the distributions are discretionary by the trustee, which means that we are reliant on the trustee to decide when to make these distributions, right? Everybody's probably wondering, what the heck are you talking about? So I will explain, right? So the beneficiary of the trust, for example, may need money for living expenses. All right, so they may need money to pitch in to pay for the house. They may need money for food. They may need money for clothing. Or if they're in a private school, they may need money for private school before age 18, certainly for college and graduate school. All right. So the trustee's got a really important role here. The trustee is going to decide when these distributions are appropriate for the beneficiary. Not going to be a whole lot of instructions under the will other than some general guidelines, and that's on purpose because we want the trustee to investigate and analyze all the different factors that go along with making these distributions. Some of these factors are, is a parent around to provide for the beneficiary? Because if so, we want the parent to pay first, right? If the parent's not around, is the requested distribution appropriate for the beneficiary, right? Oftentimes with minors, it's really the parent that's making the request on behalf of the minor to the trustee. So is that appropriate? And then the third one is when it comes time to close up and distribute the trustee has to be prepared to do that in an expeditious manner. All right. So again, up here on the slide, you see the primary role is typically the spouse. If you don't have a spouse, then who's going to fill these positions? The executor, all right, they got to outlive you. So you have to make sure that that's part of your calculus. And again, somebody that can handle financial decisions. The trustee is going to have a longer term role. If we're talking about minor kids, right? And this is a common discussion piece, talking about young kids, right? Say they're 10 years old and the trust doesn't close down until these beneficiaries are in their 20s or 30s. Well, guess what? You need to make sure that you've got a trustee that's going to be alive and able to handle these distributions throughout the course of the entire trust. If you're picking somebody who's older, well, they may not be around. All right. So as we talked about, if you're a single parent of a minor child, again, to me, it's very important that your will does a couple things. Number one, that it provides for the kids. And number two, it creates a trust for the minors. And number three, we'll add in this on your fiduciary positions. Guess what? If you're a parent of a minor child, you're going to have to pick a guardian. All right. And the guardian's going to make life decisions for the minor children until they're 18. So that's the third super important thing for your minor children. Make sure you pick the guardian. All right. Assets held in trust, again, very, very important. Because if you don't set up a trust for your minor kids, then it's likely they're either going to, these assets are going to go into the surrogates commingle fund till the minors are 18 and they all come roaring out and are given to the minor with no supervision whatsoever, which is a side issue as well. Or the guardian's going to have to be bonded for the assets. And again, you're just throwing money out the window if you don't do this. So if you're a single parent of a minor child, not trying to scare you, but I just need to make sure that you understand that you need to have a trust for minor children, preferably trusts that last up into their 20s, maybe 30, until they're old enough to handle the money. And then you need to make sure you have an executor, trustee, and a guardian that you feel be responsible to handle affairs for your minor child if you can't be there anymore. All right, what are the alternatives, the results of no plan? Well, if you have minor children that are involved, number one is who's going to be the guardian, right? If you're a single parent and there's no other parent on the scene that can provide for your children, well, who's going to make these life decisions for you? If you haven't provided instructions in your will as to who this person's going to be, it's going to cause an open issue. We've already talked about the bond for a guardian. These can be very expensive, particularly depending on how much money is being held for the minor. And if you don't want to have the trust and you're not going to bond your guardian, well, guess what? The assets are going to go into the surrogate's commingle fund and they're going to be held there until the minor's 18. And if you want them back, you have to do a complicated petition to the surrogate explaining why you need the money and what you're going to apply it for. And guess what? Now you have to hire an attorney, and now you've incurred more unnecessary expenses. A related issue too is if you don't have a will, all right, now you're into an intestacy. All right. So if you don't have a will, and this applies across the board to everybody, whether you have minor children or not. If you don't have a will, you're probably going to have an intestacy, right? That's essentially, you can think of that as the state has a plan for you, right? And that's intestacy. So what are some issues with intestacy? You're not going to be able to appoint an executor. So now you're going to have an administrator of the estate, and that administrator is going to automatically, bam, right off the bat, incur unnecessary expenses. You're going to have to post the bond. All right. A related issue is it's a little slower getting the intestacy set up. You have to explain to the surrogate the entire family tree of the decedent and explain to the surrogate's office, why you, as the person petitioning for administration, should be appointed as opposed to all these other family members, right? So the surrogate's going to say, hey, that's great. Guess what? You've got to go out and get renunciations from all the other family members who have a equal right to administration that you do. So now you have to take all these forms out and get the rest of the family to sign them. Meanwhile, the estate's just sitting there and nothing's happening. All right. And you're incurring more unnecessary expenses. A related issue for intestacy, again, this applies across the board for everybody, is you may have an inadvertent heir. All right. So intestacy is really just going to default down to your closest living relatives. So obviously, it's going to look for a spouse. If you don't have a spouse, it's going to look for kids, or it may look for a combination of spouse and kids if it's a second marriage. All right, if none of them are available, then it's going to look for your parents. If your parents aren't available, then brothers and sisters, then nieces and nephews, and on down. All right, that's who's going to get your money. Well, if there's somebody in that chain that doesn't see you, doesn't call you, could care less about what happens to you, you might not want them to receive a share of your estate. All right. Well, guess what? If you don't have a will, too bad. They're going to inherit the assets. And, unfortunately, this has come up a fair amount that we've seen with these wills with no estates, i.e. the intestacy. So the inadvertent heir issue is actually a pretty significant one, and that applies across the board. All right. So again, what are some lifetime benefits of your estate planning documents? We have powers of attorney that are available, right? And these agents can assist you with your affairs if you have an issue, right? Suppose you're not even incapacitated, you're stuck in the hospital, right? Because you have some treatment or you're stuck in rehab. Well, you can have a power of attorney go out and make some of these day-to-day chores and take them off your plate while you can focus on recovering. Early on, we talked about a revocable trust. If you want to go that route, you can fund the trust and you can have a co-trustee assist you with your affairs, and they're going to do basically the same things that an agent under a power of attorney would do. So very important documents to have available for you, particularly if you have more assets. All right, so those are some fundamental issues that are involved in estate planning documents. Again, can't emphasize enough, get your powers of attorney in place, both your healthcare and your power of attorney for finances and legal decisions. And make sure at least you have a will, all right, particularly if you have some assets. It's really important you get this done. If you have kids, you got to have all three done. All right, I can't stress for you enough how important it is, right? Whether they're minors or not, right? So if they're minors, you need the guardianship, you need the trust. If your kids are older, then you need to have a will to make their lives a little bit easier if you pass. All right, so now let's talk about estate and inheritance taxes. So unfortunately, for couples with no children and single persons, particularly in New Jersey and Pennsylvania, there are some inheritance taxes. They're going to be an adverse, I don't want to say consequence, but they're going to affect your estate adversely. All right. The estate tax, not so much. We'll talk about that as well, just so you're aware of it. So let's dig into things. All right. So these are your exemptions for the estate tax. All right. And the reason why I say the federal estate tax is not an issue for most people is because of the amount of the exemption, which you see in the far right here. So this year, the amount of the exemption is $13.99 million per person. All right. That's pretty high. So that's going to be well over 90% of people are going to be under that exemption. If you have more than 13.99 million, please call me. Call me after the seminar is over. You've got some work to do. All right. And it's pretty important work to do because the federal estate tax is fairly high. And you need to be planning for your beneficiaries if you're over the federal estate tax exemption. If you're watching this seminar and you're from the state of New York has a basic exclusion amount. This year it's 7.16 million. New York has a few quirks on the BEA, which we're going to talk about in a little bit. For everybody, there are annual exclusion gifts. This year you can give any person you want up to $19,000 per person per year. You don't have to file a gift tax return. And if you have a non-citizen spouse, you can gift that non-citizen spouse up to $190,000 this year. All right, so let's focus on the tax that's a major issue for couples with no children and singles, and that's the New Jersey and Pennsylvania inheritance taxes. We're going to talk about New Jersey first, and then we're going to talk about PA inheritance taxes. All right, so in New Jersey, just so you know, for the estate tax, the rate was reduced to zero. So New Jersey's estate tax has essentially been gone since 2018. So in New Jersey, you're really only focused on the inheritance tax, which is still on the books. All right. The New Jersey inheritance tax is based on the class of beneficiary that's receiving your assets. All right. So Class A beneficiaries are a spouse, child, grandchild, stepchild, and parent if you go up, right? So those are going to be your Class A beneficiaries. They do not pay a tax. So if you have Class A beneficiaries, you're in the clear for New Jersey inheritance taxes, all right? There is no Class B beneficiary. That's not a typo. They were repealed years ago. Class C beneficiaries, if you're leaving your assets to a brother or a sister, they're a Class C beneficiary. Or a spouse of a child, they're a Class C beneficiary as well. All right. And then Class D beneficiaries are everybody else. All right. The New Jersey inheritance tax applies to transfers that were made within 3 years of death. So if you think you're going to get out from paying the New Jersey inheritance tax by giving your money away and pass away within 3 years of the gift, well, guess what? You haven't done anything. It's all right back into your estate. So as we mentioned, Class A beneficiaries, spouse, child, lineal descendants, no inheritance tax. Class C beneficiaries, these are brothers and sisters. As you can see on the slide, there's not much of an exemption for Class C beneficiaries. So you can leave a sibling up to $25,000. Everything above that's going to be taxed starting at 11%. When you get up above 1.1 million, the next 300,000 is going to be taxed at 13%, and so on up to 16%. So as you can see, it's a fairly significant portion of your assets, and there is not a very significant exemption. All right. One other thing I'll add on this is that exemption of $25,000 is per recipient. So if you have 3 siblings, for example, you can leave all 3 of them $25,000 and you'll get an exemption for each of them. All right. I've seen that done wrong on the inheritance tax returns. So keep a close eye out on how these returns are reported. D beneficiaries, that's basically everybody else, right? So remember, A is spouse and descendants. C beneficiaries are brothers and sisters and spouse of a child. D beneficiaries are everybody else. So if you're going to leave your money to a friend, D beneficiary. You're going to leave your money to a niece or nephew, D beneficiary. You're going to leave your money to a cousin, D beneficiary. All right. As you can see on the slide here, unfortunately, there's not much of an exemption. All right. And as soon as you go $500 and over, the tax applies all the way down to $1. The first $700,000 you leave to a D beneficiary is going to be taxed at 15%. Don't ask me why, but the legislature, for some reason, increases it to 16% for amounts over 700,000. All right, we talked about the New Jersey inheritance tax rates. Let's talk briefly about the Pennsylvania inheritance tax rates. So a lot of people think, hey, I'll move to Pennsylvania and I'll avoid all these taxes. Well, not so fast, right? Not so fast. So spouses are exempt. All right, but if you know somebody that has children, well, guess what? New Jersey doesn't tax children on the on the inheritance tax, but Pennsylvania does. So Pennsylvania is going to apply a 4.5% tax to all lineal descendants, 12% for siblings, 15% for everybody else, and there's a 1-year look back on gifts. All right, New York estate tax. So New York has its own estate tax that has a basic exclusion amount, which has been indexed to $7.16 million this year. All right. The basic exclusion amount also applies to gifts within 3 years of death. And New York has a somewhat interesting way of applying the basic exclusion amount. So every 1% you go over this exemption amount, you lose 20% of the exclusion. So if you're only 5% over $7 million, you basically have no exclusion. All right. And then New York has a top estate tax rate of 16%. There's no transfer of an unused BEA to a surviving spouse in New York. So some very important taxes to keep in mind if you live in New York. This applies to everybody. I know, again, the seminar is geared towards singles and couples with no children, but the BEA applies to everybody. So it's an important tax if you live in New York, an exemption to keep in mind. All right. So let's go back to New Jersey inheritance taxes. If you're listening in PA, you just have to keep in mind, okay, well, it's relatively the same issue in Pennsylvania as I'm going to run through here in New Jersey. All right. So all these taxes sound great on paper, but you need to understand how they apply in real life. All right. So here we have an example of a decedent that wants to leave a $500,000 IRA to the beneficiary, who in this particular example happens to be a nephew. All right, but you can think of it the same thing. If you want to leave your IRA to a cousin, you want to leave it to a friend, you want to leave it to a distant relative, it's not going to matter, right? They're all D beneficiaries. If you leave it to a brother and sister, just keep in mind you'll get a $25,000 exemption. But in this particular example, that would mean the remaining $475,000 would still be subject to tax. Now, a lot of people like to think, oh, it's an IRA. It's not subject to inheritance tax. Not so fast, right? Not so fast. That's unfortunately incorrect. And in fact, the IRA is subject to New Jersey inheritance taxes, as is a 401k. All right. So here we have the example. The $500,000 IRA goes to the nephew, who's a Class D beneficiary. You may remember the Class D beneficiaries, as long as they're under 700,000, the rate is 15%. So what's 15% of 500,000? Well, the easy way to think of it is 10% of 500,000 is 50,000. Add in half again, so you add on another 25,000. So the total New Jersey tax is $75,000, right? It doesn't sound like a big tax, right? 15% doesn't sound too bad until you start running the numbers and like, ooh, 75,000, I'd rather not pay that, right? But unfortunately you do. So what's the bottom box there, right? So the top box Shows the New Jersey Division of Taxation is going to want $75,000 for inheritance taxes. So where's the beneficiary going to take the money out of, right? Well, more often than not, they're just going to go into the IRA, and they can do this because it's inherited at this point. And they're going to pull out $75,000 out of the IRA, right? And they're going to pay the New Jersey Division of Taxation, right? Let's wipe our hands, problem solved, write it off into the sunset. Well, we're forgetting one issue, right? So the IRA itself is pre-tax, right? Which means all distributions from the IRA are subject to inheritance taxes. So by removing the $75,000 from the IRA to pay the New Jersey Division of Taxation, now your beneficiary has to report $75,000 in income, which is going to go on their 1040. And now they're going to have to pay income taxes on the amount that they removed to pay the inheritance taxes. So you can see it's somewhat of a double whammy for these and can have somewhat of an adverse effect on your beneficiaries. A related issue is who's paying the inheritance tax, right? So on that example that we just ran through of a $500,000 traditional IRA, the nephew paid the inheritance taxes by withdrawing the funds from the IRA account. Sometimes people draft up their will and not really think about what they're doing, and they'll just slap a clause on there and say, oh, I'll pay all inheritance death taxes from the residue of my estate, which sounds great, but we'll tell you why that can be an issue here in a second. If that residuary tax clause is not in the will, then absent a direction under the will, the beneficiary or recipient is responsible for paying all New Jersey inheritance taxes. All right, so here's why failure to plan your will out can be an issue with regard to inheritance taxes. And I'm going to give you an example. All right, so before I run through the example, I admit there's a lot of information up here. I'm going to do my best to try and explain it to everybody and make it easy. So we have a hypothetical decedent, right? And they have 4 different assets. They have a bank account worth $500,000. And they decided, because they talked to the bank employee, to put a payable on death provision, which creates a beneficiary on that account and allows the asset to flow directly to the niece. All right, so that's that. There's also a $250,000 CD payable on death to a friend. Then you have a $600,000 investment account that's also payable on death to a cousin. And then you have a $150,000 investment account payable on death to friend number 2. All right, so everybody up there is a Class D beneficiary, meaning all these assets are going to be taxed from $1 at 15%. If I did the math correctly, I totaled up the assets at 1.5 million, multiplying that by 15%, you're going to owe $225,000 in inheritance taxes. So now we have to figure out how we're going to pay the tax. So typically, the state of New Jersey is going to look at the executor of the estate. Remember, we talked about that earlier. That's that individual that you appoint under your will to manage your estate for you. The New Jersey Division of Taxation is going to come to the executor and say, hey, you got to file a return and you got to figure out how to pay that $225,000 in inheritance taxes. Well, what's the problem with this estate? Well, there are a couple, right? So the one we're going to talk about right here is how's the executor going to get their hands on the money, right? Because the executor is just handling assets by the will. Well, how many assets are passing under the will? Which would be the quote probate estate that you see on the slide. I put the answer for you. It's 0. So none of the assets are payable through the estate. They're all payable directly on death, which means the financial institution is going to handle the transfer to the beneficiary, meaning the executor can't get their hands on any of these assets. Here they all are, right? Because they're all payable on death. No, number 1's payable to the niece. Number 2's payable to friend number 1. Number 3 is payable on death to a cousin, and number 4 is payable on death directly to a friend. So none of these assets are passing under the will. how is the executor going to get their hands on these assets? So absent some cooperation from the beneficiaries, which unfortunately in today's world, cooperation seems to be more the exception than the rule, the executor may have some problems. If you don't have a will and you get an administrator appointed, same issue, right? Same issue. That administrator is going to have a difficult time getting their hands on those assets. All right. So that's an example right there of failure to plan your estate properly so that the executor has access to assets so that they can pay off the inheritance taxes. All right. Even worse, what if the will says that all the taxes are to be paid from the probate estate or the residue? Well, guess what? There's nothing to pay the taxes from. All right. And then let's talk about a related issue, which is the last bullet point on this slide. That's the New Jersey inheritance tax lien. All right. So by law, the financial institutions are required to hold back half of the assets until all the inheritance taxes are paid, and a lien release is issued by the New Jersey Division of Taxation. In lieu of this, sometimes the beneficiaries will sign an L8, which is a lien release form, and submit that directly to the bank. Here they would be lying if they filled out the L8 respectfully, and shouldn't do it, but sometimes they'll go ahead and do it anyway, which creates an issue of its own. So looking at these assets, what are we talking about here? Whoops, went down instead of up. All right, so going back to these, so that means that at most on the $500,000 bank account, the niece gets half, 250, meaning the financial institution is going to sit on the remaining 250, and we can just run down the list, right? The $250,000 CD, the friend's going to get half. They're going to get 125 at most. The $300,000 investment account, same, 300,000 gets held back by lien. The remaining 300,000 just sits in the investment account. And then finally, the 150, the beneficiary gets 75,000, and the remaining 75,000 can be paid over to the beneficiary. So these lien amounts are held by the financial institution until they receive a lien discharge from the state. And again, that further complicates the administration of the estate. Again, a lot of this can be avoided either A, if the will is properly drafted in coordination with these payable on death provisions, or B, you have a revocable trust. And rather than do these POD directly with the financial institutions, you just name beneficiaries and fund all the assets into a revocable trust, which is exempt from these liens. All right. So here's another example. The financial institutions will only release 1/2 of the account value to the beneficiary. So by example, the $500,000 bank account payable on death to the niece. So the financial institution should only release half of the account until the inheritance taxes are paid, meaning the niece should at most only be able to access 50% of the account, and the remainder of the account will be paid over once the lien releases are issued by the state. By the way, that takes a few months, and the lien releases are provided to the financial institution. All right, so those are some of the major tax issues in estate planning dealing with singles. All right. If you live in Pennsylvania, you're going to have many of the same issues that we just ran through with New Jersey, keeping in mind that non-spouse, non-children beneficiaries in PA are also going to be subject to inheritance taxes, and you have to figure out exact same issues, how you're going to finance those tax issues in Pennsylvania. Let's talk about just a few non-tax issues. I do see that it's 1:15, and I'm going to try and speed this up because I know many of you have to get back to work. So some major non-tax issues are, beneficiaries dying, or there's a divorce of a beneficiary. So what's the issue here is basically you have an unintended beneficiary of your assets. If you're the decedent and you leave your inheritance to a beneficiary who doesn't last very long and they die very soon, or suppose there's a divorce that's involved. Well, guess what? Significant amount of the inheritance from your estate may pass to the beneficiary spouse, and then if there's a remarriage later, may wind up with new spouse who's not your beneficiary. So that's one of the single biggest non-tax issues that we see in estate planning. People are very concerned about what the beneficiary does with the money vis-a-vis a spouse or a partner. We can put many different scenarios here. It doesn't have to be a spouse. It could be a partner or a friend or somebody who's involved in the beneficiary's life. The beneficiary receives this inheritance. There's a lot of pressure on the beneficiary. What are they going to do? Maybe put it into a joint account with this third party, in which case all bets are off, or they may just spend it or gift it to others. So this is a major issue. If you think any of your beneficiaries are affected by this potential issue, then you need to head off the problem as part of your estate plan. All right. A related issue too is, what if the beneficiary has spending issues or dependency? Kind of one of the most depressing things I see in estate planning are some of these beneficiaries that have substance abuse issues. If you're leaving somebody an inheritance and they suffer from substance abuse, you need to look in the mirror and you need to determine whether you're actually doing them a favor or not, because it may very well be that you're doing a beneficiary a huge disservice by leaving them money when they have a substance issue. Because what are they going to do with the money, right? I like to think of it as, rather than leaving the money to the beneficiary, you've left the money to the substance abuse issue and you've now fueled it and made it worse. All right. So very important issue. Sad to say, that's becoming more and more common in today's society, but it's really something you need to think hard and long about. Another issue is if your beneficiary just can't manage money. That one, you have to make a decision. You may be okay with it, realizing, hey, if I leave them money, they may just squander it, right? You may, well, there's not really a whole lot I can do about that. I'm just going to leave it to them anyway. Or you maybe need to set up some type of trust for that individual, in which case you have another person or entity serve as trustee and disperse the estate or inheritance to the individual over time, or just pay it out directly to third parties for the beneficiary's benefit. So essentially you have another person managing their assets for them. So that's a different way of handling it too. But again, this is a major issue here, and sad to say, one that we're seeing more and more of. One option too that you might have is, you can, rather than leave the money outright to the individual, just put it into trust for them. On the screen, what you see right here is, rather than just a simple plan, this individual's created a trust. They have two different beneficiaries. They create two different sub-trusts for each of the beneficiaries, right? And then just an example of how these could work. Again, there's lots of different terms that you can place on a trust, but one very common one is that you pay the income distributions over to the beneficiary and make discretionary principal distributions to them, as well as discretionary distributions for the beneficiary's children. And that would all be done by the trustee, which is that very important person that we talked about earlier in the slide, who's going to be A, managing the money for the beneficiary's lifetime, and B, determining under what circumstance we're making these discretionary distributions from the trust. So a very, very important position and role to fill. All right. So I know I covered a lot here today. I do want to wrap it up and keep within our time limits. Some important things are, do you have an estate plan? And I would incorporate within that question whether you have powers of attorney, a healthcare power of attorney, or a power of attorney for financial and legal decisions. If you're single, you've got some work to do. You have to figure out who these fiduciary positions are going to be filled by, and making sure that the people you do choose are appropriate for each of the roles. If you're a couple with no children, again, you may put the spouse in as primary. Your issues are going to be somewhat more limited. You're going to have to figure out who's going to be your power of attorney and executor, if the spouse predeceases you. All right, so the estate planning documents are super important. We reviewed federal estate tax. Again, that's $13.99 million exemption. Probably not going to affect most people, but there are a few that do. And, please call me if that's an issue for you. More importantly are the inheritance taxes that you have in both Pennsylvania and New Jersey. They need to be assessed as part of your overall estate plan. It's difficult to, quote, avoid them, end quote, but there may be some ways of trying to minimize the overall impact of these taxes on your beneficiaries. All right, so those need to be assessed and evaluated as part of your overall estate plan. What's an example? Instead of leaving money directly to a niece or nephew who'd be a D beneficiary, perhaps you leave it to their parent who's a sibling who does have albeit a small exemption of 25,000 and a slightly lower inheritance tax rate. There's one example of how these taxes can at least be evaluated and minimized as part of your plan. There's some major non-tax issues in this type of estate planning. Frankly, avoiding inheritance taxes is great, but these non-tax issues can often cost your estate and your beneficiaries far, far more than the taxes ever do. All right, so if these issues affect your estate plan, it's something that you need to be on your radar screen and addressing. Again, what are some basic ones? If you have minor beneficiaries, you need to address that. If you have beneficiaries you're concerned about their family situation, do they have a stable marriage, do they have somebody involved in their life who's maybe not the best, that needs to be evaluated and perhaps direct distributions avoided in lieu of a trust. And the last one is if you have beneficiaries that have special needs or alcohol or substance abuse issues, those need to be addressed as well. Again, can't stress enough, there are many estate and trust planning opportunities and options to attempt to deal with some of these issues. I'm happy to review them with anybody. If you have any questions, my number's there on the screen. You're also free to email me at rmorris@stark-stark.com. Happy to address things via email. And finally, I just want to wrap up today. I do thank you for joining me here today. I wish you the best today and as your life unfolds. And if you have any questions, I'm here to help you and try and navigate some of these issues. Thank you.